When someone passes away in Minnesota and they own a home, one of the very first things the family asks is, what happens now? What happens to the house? Can we sell it? Who's even allowed to sell it? Do we have to go to court? In this video, I'm going to walk you through exactly what happens to a house when someone dies here in Minnesota, whether it has to go through probate, the three situations where it doesn't, and what you actually need to do first. I'll keep it simple and in plain English because this is hard enough already. My name's Arne. I'm a realtor here in the Twin Cities, and over the years, I've helped hundreds of families buy and sell their houses, and I've helped a lot of families who have had to sell a house of a loved one, like their mom, their brother, or their sister. And some of these homes really needed a lot of work, and that is where my construction background comes in. But one quick point I want to make is that I am not an attorney. So everything in this video is just general information. It's not legal advice. For your exact situation, you'll want to talk to a probate attorney. But if you're going through this right now and you want someone to help you understand your options and what the home is actually worth, there's a calendar link down in the description. You can book a free call, no pressure, no obligation, whether you're ready to sell or you're just trying to figure out what your first step is. So let's start with the single most important idea in this whole video, because once you understand it, everything else falls into place. So whether the house has to go through probate in Minnesota depends almost entirely on one thing: how the home was titled. Not how much it's worth, not whether there's a will, how it was actually owned on paper. That's the hinge the whole thing swings on. So as I walk through this, the homework I want you to do is simple. Find the deed or look up the property in your county's records online and figure out exactly whose name is on the house and how. That one document is going to answer most of your questions. Let's go through the situations, starting with the good news, the three cases where the house skips probate completely. The first one is joint tenancy with rights of survivorship. If the home was owned by two or more people, very often a husband and a wife, as joint tenants with rights of survivorship, then when one owner dies, the surviving owner automatically becomes the full owner. There's no court process for that. It just takes some paperwork and a certified death certificate to clear the title into the survivor's name. Now, here's the trap to watch for. If the deed says tenants in common instead of joint tenancy, that's different. With tenants in common, the shares owned by the person who died does not automatically pass to the co-owner. It goes through probate. So the exact wording on the deed matters a lot. The second way a house avoids probate is a transfer on death deed, sometimes called a D or a TOD deed or a beneficiary deed. Minnesota lets a homeowner sign and record a deed while they're alive that names who gets the property when they pass. The key word is recorded. It has to be filed with the county before the person dies to be valid. If one of these is on file, the house passes straight to the named beneficiary. No probate is needed. If you've seen a TOD deed, this will make families it will make it dramatically easier for the family. And the third way is a living trust. If the home was placed in a trust during the owner's lifetime, then the person they named as successor, the trustee, can transfer or even sell the home without going through probate court at all. So those are your three off ramps: joint tenancy with right of survivorship, a recorded transfer on death deed, or a trust. If any one of those is in place, you're likely in good shape. Now, here's a situation that catches the most families off guard. If the home was titled solely in the name of the person who died, no co-owner with survivorship, no transfer on death deed, no trust, then the house has to go through probate in order to transfer or sell it. And this is the part people don't expect. That's true regardless of how much the home is worth. It doesn't matter if it's a small starter home or $1 million lake home. If it's in the deceased person's name alone, it goes through probate. And the reason is actually pretty logical once you hear it. Think about it from a buyer's side or the title company's side or a bank side. Nobody is going to accept a deed signed by a person who doesn't legally have the authority to sell the house. The owner has passed away. So who's allowed to sign? The answer is nobody until a court officially appoints someone and gives them the authority. That court appointment is a huge part of what probate actually does. So I'll tell a story about a client where his mom passed away and he was appointed the personal representative, and we had to wait for the probate hearing to actually, well, he was appointed the personal representative, but we had to wait for the hearing to actually make him the personal representative. So it does take some time to get the court to actually process that so then you can sell the house. So this is a good moment to clear up the single biggest misconception I hear because it trips people up constantly. A lot of families have heard that Minnesota has a small estate shortcut, that if an estate is under $75,000, you can skip probate and just use a simple affidavit. And that's true, but only for personal property. That $75,000 small estate affidavit covers things like bank accounts, vehicles, and belongings. It can be used starting 30 days after the death. But here's the catch that matters for everyone watching this video. Real estate cannot be claimed with that affidavit. A house is specifically excluded. So if there's a home titled in the name of the person who died, you almost always cannot use the small estate shortcut for it. You're looking at real probate. I just don't want you to find that out 3 weeks into the wrong process. Okay, so let's say the house does need to go through probate. I don't want that word to scare you. So let me show you what it actually looks like in Minnesota step by step. It starts by filing in the county district court where the person lived. And there are really two versions of probate here. The first is informal probate. This is handled by a court register, usually without any hearing in front of a judge. And it's the path most uncontested estates take when there's a clear will or clear heirs. It's faster and less expensive. The second is formal probate, which does involve a judge and a hearing, and that's used when there's a dispute or the situation is complicated or someone asks the court to supervise it more closely. Either way, early in the process, the court appoints a personal representative. You might know that role as the executor. That's the person who gets the legal authority to act on behalf of the estate. From there, the personal representative inventories the assets and notifies creditors. Those creditors generally have about 4 months from the published notice to file any claims. The estate's debts and taxes get paid, and then whatever is left over, whether that's the house itself or the money from selling it, gets distributed to the heirs. That's the whole arc: file, appoint, inventory, pay debts, distribute. It's a process, but it's a well worn one, and thousands of Minnesota families go through it every year. Let me give you the timeline so you know what to expect and you're not caught off guard. First, there's a clock on the front end. Probate generally has to be started within 3 years of the date of death. That's more strict than a lot of other states. So it's not something to sit on indefinitely. As for how long it takes once it's open, most estates run somewhere from a few months to about a year, depending on how complex things are and whether anyone contests anything. On taxes, two quick things, and then we'll move on. Because for most families, this won't apply. Minnesota does have a state estate tax, but it only kicks in on estates more than $3 million. And when it applies, there's a return due about 9 months after the death. Most estates are nowhere near that, and there is no separate inheritance tax in Minnesota. The heirs aren't personally taxed just for inheriting. If your estate might be more than $3 million, that's a conversation for a CPA, not a YouTube video. Now, here's a question I get more than any other, and it's probably the reason a lot of you clicked: can we actually sell the house? And the answer is yes. Once the court appoints a personal representative, that person can list and sell the home. It sells on the open market just like any other house, and the proceeds go into the estate to be paid out to the heirs. So a home being in probate does not mean it's frozen or stuck. It just means the sale has to happen in the right order with the right person authorized to sign. And honestly, helping families through that, selling a home during or after probate, often a home that's dated or need work, is something that I do all the time. It doesn't have to be overwhelming when you've got somebody who's done it before walking next to you. So if you're sitting there thinking, okay, Arnie, where do I even start? Here's your first step. It's very simple. One, order several certified copies of the death certificate. You'll need more than you'll think. Two, find the will, if there is one, and locate the deed to the house. Three, check how that house is titled. Pull up your county records, property records, because like we talked about, that tells you whether you even need probate at all. And then four, talk to a probate attorney to confirm the right path for your specific situation. And five, and this one's the contractor in me talking, secure the property. If the house is going to sit empty, keep the heat on and get it winterized. I've seen frozen pipes burst in empty inherited homes that do tens of thousands of dollars of damage and wreck value before the family ever even gets to sell it. So in a Minnesota winter, that's not a small detail. Protect the assets while you sort the rest out. So what happens to a house when someone dies in Minnesota? It really does come down to how the home was titled and whether it has to go through probate to transfer or to sell. I know that's a lot to take in, especially now, so please don't try to carry all of it by yourself. If you'd like to just talk through with someone who's helped families do this many times with zero pressure, zero obligation, book a free call using the calendar link in the description, and I'll help you understand your options and what the home is realistically worth today. If you're getting closer to actually selling, watch my video on selling an inherited house in Minnesota next. It picks up right where this one leaves off. And if this helped you, do me a favor and subscribe because I make calm, straightforward guides for situations exactly like this. Take care, and I'll see you in the next video.